okay, Bill?
Thank you. Take care. Bye-bye.
Yes, sir. All righty. You're listening to the Attorney Patrick Smith Show, and this is your host, Attorney Patrick Smith. You can call in now with your legal questions, 877-943-9673, 877-943-9673. Open phone lines will get you and your question right on the air, and you can also email your questions. We actually have our first email question of the day. I have Peter, the intern, here in the studio with me, feeding me the email questions as they come in, just so you know. So the first email question of the day is, do I need a new will if I move to Florida from another state? This is the most common question that I get, not only on the radio shows that I've done, but also in person, in client meetings. It's, is my out-of-state will or trust valid in the state of Florida? And the answer is maybe. It really depends on whether or not the document was valid in the state where it was created. If it's valid there, then it's valid here in Florida. But the question, the better question, as opposed to is the document valid, is that document the best document for you? Is it the most optimal document, the most efficient document for you and your family? Oftentimes that's not true for two reasons. One, if you have an old out-of-state will or trust, pull it out. Dust it off. Take it out of that family safe and take a look at it and read the first line. It probably says something to the effect of, I, a resident of, and it probably has the wrong city and state. So, number one, we're not past the first line and your residency is wrong. It's not catastrophic, but it's certainly inefficient. And furthermore, oftentimes the issues we run into with out-of-state documents are the fact that they're not self-proving. See, Florida has certain requirements for valid documents versus what we consider self-proving documents. Self-proving documents in Florida are properly witnessed, notarized, have appropriate affidavit language, and require no further proof. If the document comes from another state, even though it's valid, it may not be considered what Florida calls self-proving and may require additional proof upon your passing. That is to say this: if you moved from another state to Florida, it's probably wisest to have your documents reviewed. That's why we offer a complimentary estate planning consultation. So you can call the office, bring in your out-of-state documents free of charge. We will look through everything, make you our recommendations, give you a quote for our services, and that way we can give you some peace of mind as far as whether or not just if are your documents valid, whether or not they're the best version of those documents for you and your family. So you can feel free to give us a call during the week at the office, and we'll get you set up to review those documents. And it is funny, sometimes clients call and they say, hey, is my out-of-state will valid? And they almost expect you to be able to review the documents without actually looking at them. You actually have to put your eyes on them and see the documents for yourself. I mean, to give an opinion on a legal document without seeing it, that doesn't sound like the wisest thing to do. So we actually have to put eyes on, and we'll be happy to do that in a free of charge estate planning consultation. 877-943-9673, 877-943-9673. You can give us a call now, and your question will go right on the air. We have open phone lines, so your question will be right at the top, 877-943-9673, or you can email your question directly to me, Patrick at attorneypatricksmith.com, Patrick at attorneypatricksmith.com. This is the Attorney Patrick Smith Show, where you can call in every Saturday morning free of charge and get your legal questions answered. And we're here to do one thing, and that's help you. So like I said last week, maybe during the week something popped up and you said, boy, I really wish I could speak to an attorney about it. I would feel better. Or maybe you know of a friend. Maybe there's someone you're thinking of right now who you know is facing an issue like that. And you have time to shoot him a quick text. Say, hey, the attorney's on the air. Give him a call, and he will be happy to give you the best answer he can, just like Bill from Winter Haven did. 877-943-9673. Another common issue that we get at the office during the week is how often should we review our estate planning documents? So we're not moving in from another state. We're here. We're in the state of Florida. We've been here. How often should we sit down with our attorney to review it? My rule of thumb on this is 3 years. I think that's a good number, just sort of legislative cycles wise. I think that's a good idea. But I also think that's not a hard and fast rule. I think you need to be a little more dynamic when it comes to your estate planning. And I think that what you want to do is set it up so that you revisit your estate planning documents anytime there's sort of a major change in the family or major change in your life. There's a major increase or decrease in the family wealth, new births, deaths, anything like that. I tell my clients, I say, look, if in doubt, call me. Calling me is never the wrong answer. And I would rather a client call me and us have a 30-second conversation that they may seem or think is a little silly, as opposed to not calling me and having something go unaddressed. So when we have these reviews with clients who have been clients for years, oftentimes they're just simple, quick, and happy greetings. And sometimes we discover things. They'll say, well, I forgot that I put my brother in charge. My brother's passed away, or he's battling cancer. There's no way he could do this job now. We need to make some modifications there. So at the end of the day, I think that reviewing your documents every 3 years or anytime there's some sort of major change in the family situation, whether it's financially or fundamentally with family members being born, passed away, something of that nature, I think that that's a good rule of thumb. So 877-943-9673, that's your toll-free number. Give us a call now. We'll get you and your question live on the air. 877-943-9673, or email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. Also available for free speaking engagements. We do speaking engagements all across the great state of Florida, and we speak on a wide variety of topics. Topics include estate planning. We're actually preparing for the new Biden administration tax legislation once that's actually officially passed. A lot of murmurings out there right now about what it's going to look like, the consequence from it, and whether or not it's actually going to be feasibly enforced. So a lot of buzz out there regarding that. For years, we lectured on the new Power of Attorney Act. Since 2011, October 1 of 2011, when the major statutory changes to the Power of Attorney Act shifted. So maybe you have a group or a club that's in need of a speaker. We'll be happy to come out absolutely free of charge and speak to your group. Usually we can speak for 20 or 30 minutes. We actually customize the speaking engagement for your group, and then we usually leave some time for Q&A. That's my favorite part because it gives me a chance to see what's on the minds of the public, so to speak. And we'd be happy to set that up for you. You can reach out to me directly, patrick@attorneypatricksmith.com, or you can give me a call now, 877-943-9673. That's your toll-free number. Open phone lines. We'll get you and your question right on the show, 877-943-9673. Let me give out the office phone numbers. If you're listening in Lake County, the number to reach us at the office is 352-204-0305. In Pinellas County, it's 727-335-7094. Hillsborough County, it's 813-755-8400. Orange County, 407-606-7158. Or Polk County, as we told Bill earlier in the call, 863-445-9239. And I'll repeat those later in the show. In the meantime, feel free to give us a call. We'll get you and your question right on the air, 877-943-9673. A lot of times, small business owners will come in during the week and they'll ask questions regarding LLCs and whether or not they should have an LLC. We absolutely recommend having LLCs as a great way to protect your personal assets from professional liabilities. But a lot of people have this misconception that somehow registering a fictitious name on the internet through Sunbiz is somehow the finishing line for LLC creation. And at the end of the day, it's just the starting point. Really what it comes down to is how well you maintain that LLC once you've created it. Because what we're worried about, what we're concerned about as the attorney for someone with an LLC is something called piercing of the corporate veil. In other words, when someone sues an LLC, how likely are they to set aside that LLC to get to your personal assets? That's going to be a direct correlation to how well you've maintained the LLC. And maintaining the LLC means not just registering with the Secretary of State, but it means also how well did you keep your corporate records? Did you keep your personal expenses separate from your corporate expenses? Did you file your annual reports? And all those sorts of maintenance things, when they look at it from an arm's length position, does this look like an LLC or does it look like a de facto personal account? So I think that's the main thing business owners need to understand, is that it's not just about creating the LLC, because I think that's a common misconception. It's about maintaining that LLC and those corporate records. And there are some famous cases out of other states regarding, medallions for operating taxis. And there was one particular case where one particular owner owned hundreds of those medallions, and he had each one in a separate LLC, so that if one was in an accident, the others were protected. And this was by design, as a liability protection, and the records were meticulously maintained. This was the point of this case. It wasn't just about setting it up, it was about how it was maintained. And in this case, everything was maintained, so there was no piercing of any corporate veils. So maybe you have an LLC question. Maybe it's regarding a rental property, foreclosure action, anything at all. We'll be happy to help you any way we can. 877-943-9673. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943, or you can email your questions to patrick@attorneypatricksmith.com. And you can also submit questions live over the live feeds, over Facebook Live, if you're watching on Facebook Live, or if you're watching over Instagram Live, you can submit your question directly live on the feed, and we'll answer it live on the air as well. So this is Attorney Patrick Smith. This is the Attorney Patrick Smith Show, and we're here to help you in any way we can this morning. And we're here to help you during the week as well. So I'm in the office 5 days a week, and we'll be happy to meet with you for your complimentary estate planning consultation. People ask me all the time, they say, Patrick, I want to know what the charge is going to be. Well, first of all, there's no charge for our consultations. And then people say all the time, well, what's it going to cost me to do a will? Our fee for a will is $75. And that is the total charge. I had a young lady call many Fridays ago now, and she said to me, Mr. Smith, I understand that you do wills for $75. And I could tell by the way she said Mr. Smith that there was an edge to her voice. And she said, what is your hidden fee? And I said, well, if I told you what it was, it would no longer be hidden. Now, would it? There's no hidden fee. It's $75 for the will, which is the document wherein you will pick your personal representative. A lot of people call this executor. Florida's term under the statute is actually personal representative. This is the person who's going to marshal your assets. They're going to pay your creditor claims. They're going to prepare and file that final tax return. They're going to prepare the estate accounting and ultimately do the most important thing the will does, carry out your distribution. So for $75, we can set that up for you, where you get to pick who's in charge, where you get to pick who you want your assets to go to. And this avoids a terrible outcome called intestacy. So if you pass in the state of Florida and have no will in place, you have a plan. You just you don't know anything about it because you didn't design it, and it's written by state statute under the probate code. And this oftentimes produces terrible outcomes. And at the end of the day, you have a chance to avoid that outcome by putting your wishes or your will together in a document that's going to cost you $75. Our power of attorney documents are $95. Our living will documents are $50, and our trust package is $695. And the package includes the trust, the pour-over wills, the power of attorneys, healthcare surrogates, living wills, the deed for the home, and that is for a single person to do all of those documents. And right now, married couples can do that same package at no additional fee. There's no extra charge for a married couple when they're doing the same plan, essentially. It's still the same $695 that you can pay for that same coverage, and all the ancillary documents are included. And that often leads to a point where people say, well, Patrick, well, there's the key decision right there. It's going to depend on what's cheapest. And it's true. It's not lost on me. $695 is a lot of money. And at the end of the day, a lot of people say, I don't know that I have that money. I don't know that I can afford the trust because it's so expensive. And it is in the short term. But let's not lose sight. A will is not finished costing us money simply because we created it and paid the attorney $75. Remember, wills still have to go through a process known as probate. And that probate process in Florida kicks in when the assets, outside of any exemptions, are in excess of $75,000. And if it's a formal probate, on average, it takes anywhere from 6 to 14 months, and it costs anywhere from 3 to 10%. So that being the case, if you compare apples to apples, in the long run, oftentimes trust are the least expensive option by the fact that they avoid the probate process. And there's some other advantages to trust. We'll talk about those in a little bit. But let me give out the phone number in case you have a question about your trust or some other estate planning topic or any other legal topic at all. 877-943-9673. 877-943-9673. You can give us a call now. Open phone lines, and we will be happy to take your call and put you right on the air and give you the very best legal question or legal answer to your legal question that we can. So people oftentimes, especially up in the village's office, it's common that people understand that a trust avoids probate. Indeed, you can see all over the villages, people understand that, and it's to the point where it's almost like they're repeating a catechism to you, the fact that they're avoiding the probate process, and they understand that a trust avoids that. But when it goes beyond that, when you press and say, what is the other, or what are the additional advantages to a trust beyond avoiding probate? Because there are some. Indeed, one of the big ones is incapacity planning. With regard to trust, they don't just avoid probate, but they also structure a plan so that if you lose capacity prior to your passing, you've designated someone called a successor trustee to take over and captain your family's financial ship and steer it clear of potential hardship. Statistically, most of us will be incapacitated for some period prior to our passing. And furthermore, the statistics bear out that usually the final 30 to 90 days of someone's life are the most expensive days that they ever live. So having someone that you've pre-selected to be responsible with your family's financial wealth can reduce or eliminate a lot of those major expenses. Major expenses like nursing homes or things of that nature. But having someone there who's savvy financially, and in addition to that, someone who has your best interest at heart and is familiar with your finances. So someone in that particular category, captaining your family ship at a time when you're vulnerable because you cannot do so, it is extremely critical, and it's one of the most unsung advantages to a living trust because it often gets overshadowed by the fact that it avoids probate. Alrighty, let's go to Tampa and talk to Joe. Joe, welcome to the Attorney Patrick Smith Show. How are you today?
Doing well, Patrick. Thanks for taking my call, and
Sure.
Good morning to you. Have a friend who explained a legal situation that he and his family are dealing with, and I think this probably is something that's in your area of expertise. He had an uncle who had been dealing with health issues for a period of years, and he knew that, and he had a significant estate and was kind of in the process of determining, what to do with that. Towards the end, he had a meeting with the members of his family that, were kind of the decision makers, and kind of made his wishes known about what he wanted to have done with with what he was leaving behind. And there's a variable here where one of his children, he has 3, and one of them has had off and on substance abuse issues that the whole family has been very concerned about, helping him through for all of these years. And they didn't want it to be a situation where he was given a giant lump sum all at the same time and could potentially exacerbate his, addiction issues and so on. Well, the uncle passed away, and while all of these wishes were expressed prior to his death, none of it was ever put into official documentation. I asked him if he had done a will or anything like that, and the answer was no, but the entire family knew what the wishes were. So my question for you is, absent some kind of a binding documentation, is there any recourse for the family now since there wasn't anything set up in advance to prevent the situation where the problem child, the one with the abuse problems, would be potentially getting this lump sum that they're concerned would be a problem for the addiction issues that he has.
Yeah, it's a fantastic question, Joe, and let me repeat it just for everyone to make sure that I understand it. So the question is, you had an uncle, and there were some family discussions, family meetings, very common to occur, where you sort of kick around different ideas for how the estate plan is going to go. But the short version was he passed before anything was codified in any sort of written instrument. Is that accurate?
Yeah, it was a friend of mine's uncle, and they made these wishes very clear what he wanted, but like you say, it was never codified into any documentation.
Okay. And so the friend whose uncle passed away, when his uncle passed, was he married?
He was, his wife had been deceased. He was a widower.
So he was a widower, and he had how many children total?
3.
So he has 3 children. He died intestate. And the state code, off the top of my head, is going to say that the probate code is going to leave that to his 3 children outright. So your question to me is there any way that the courts can step in and say, well, let's hold on. We can set aside this third for him, but handing a third to him outright
exactly
is going to be catastrophic for him considering his substance abuse problems.
That's right.
I think there's a possibility there. I mean, you would just have to seek some sort of judicial modification. I'm not real positive or optimistic that it's going to work, Joe, to be honest with you. But at the same time, let's presume that the estate's over $75,000. So we're doing a formal administration. We have a personal representative that's appointed, okay? And their personal representative is bound with this fiduciary duty to do what he believes or she believes is in the best interest of the beneficiaries. So if you've got a beneficiary with a substance abuse problem, how do you justify in your mind that it's in their best interest for you to hand them $300,000? And I'm making up a number. I have no idea what this estate is valued at. So I think that, as far as good faith, I think you could say there's room to make that argument before a court and say, Your Honor, we have no problem with the shares being a third, but we would like to create some sort of argument for some sort of trust creation or some sort of stagger distribution in order to make sure that this intended blessing of an inheritance doesn't turn into a curse by enabling this terrible addiction.
Okay, very good. That's actually better than what I thought I was going to hear.
Yeah, I mean, like I said, it's really what county was it Hillsborough County?
I think it's Pasco.
Pasco County. So it really just depends. I mean, it depends on. I think also the other determining factor here is if all 3 parties are in agreement. Now, that means you're going to have to get the potential person with the substance abuse issue to agree to this. I think you have a much greater likelihood of success on something like that if they're all 3 in agreement. If the person with the substance abuse problem objects to this, my confidence in this prevailing drops significantly.
Got it. So if you're able to convince the party that everybody's concerned about to kind of go along with this, then they've got more options.
Yeah, where I think you don't have any option is the third. And families often think of this, Joe. They think, well, as long as we agree to it, we can do whatever we want. And that's not the case. The law is the law. It's like when someone writes a will and it says we're going to do, 30% to A, 20% to B, and 50% to C. And the family says, well, we're agreeing to divvy it up differently. You can't do that. That's maladministration. You've got to honor the decedent's wishes. And here, where there were no written wishes, you have to honor what the state code put in place for them, and it's equal shares. Now, as far as the receipt of those shares, I think that's where there's room for good lawyering as far as saying, well, what is in the beneficiary's best interest here? And I think that's where you can make the argument. But with a beneficiary objecting to it, I think it's a lot less likely for success, but it's something worth consulting about. I mean, it's going to be intensely fact specific, as most probate and trust administrations are, especially when they turn adversarial. And I'm not saying this one would, but they turn on a dime in these cases. So it's something worth looking into, and we'd be happy to give you a free consultation, or your friend a free consultation regarding that, Joe.
Oh, great. What's the best way to reach your office?
So in Hillsborough County, which would be the nearest we would have to Pasco, it's 813-755-8400.
Sorry, could you say that again? I was writing it down.
Yeah, 813-755-8400. Or if he's closer to Pinellas, it's 727-335-7094.
Very good. Okay, thank you so much. You've been a great help. I'll let him know.
Joe, I appreciate you calling in. Have a great day, okay?
You too.
All right. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Open phone lines will get you right on the air. 877-943-9673. 877-943-9673. Open phone lines. You can also email your questions directly to me, Patrick, at attorneypatricksmith.com. That's also a great way to reach me during the week. You can also reach me at any of the office locations. During the week, we'll be happy to return your call, answer your questions as best we can. And we have another email question that came in. Peter, the intern, was nice enough to pass it along to me. It wants a discussion on the differences between a power of attorney and a healthcare surrogate. Great question. So oftentimes, when you talk about a power of attorney, people tend to think of just financial decision-making, which indeed, when you craft a power of attorney, which a power of attorney, for those of you who aren't familiar, it is a principal and agent relationship. You are giving power to someone to make decisions for you, and you get to craft or design the scope of those decisions in the document. You can make it very broad, or you can make it very narrow. Yeah, that's up to you. And you are giving, you as the principal are giving power to someone known as the attorney in fact. Clients all the time ask if that's us, or no, we're the attorney at law. The attorney in fact is the person to whom you've designated the power. A healthcare surrogate is simply someone you've picked to strictly make healthcare decisions. No financial decision making. Now, oftentimes, it's the same person. So under Florida Code, you can actually merge the two documents into one instrument. You can have a power of attorney for financial that also covers healthcare surrogacy. But sometimes it's different. Sometimes, you say you have a family and the mom and the dad are picking the kids, and one kid is a financial wizard, and then the other is a practicing physician. So what they'll do in that case is say, well, the one who's the financial wizard is going to be my financial power of attorney. The one who's the physician is going to be my healthcare surrogate. That just makes me feel better. But so you can bifurcate the two, but you can also unify them in one instrument. The best answer is whatever the client wants to do. But that's your discussion on the differences between power of attorneys and healthcare surrogates. Alrighty, next we're going to go to Dave in Sarasota. Dave, welcome to the Attorney Patrick Smith Show. How can I help you today?
Hi, thank you very much for taking my call. I have a quick question. My parents passed away in the Midwest last year, and they had a trust. I'm a resident of Florida, and I was willed their house in Florida. And so our attorney in Illinois said I had to find an attorney in Florida to do the process of transferring the title over to my name. And I'm just curious about how long of a time frame that takes to do that process.
Well, if it was a Florida administration all the way around, meaning it was a Florida trust with Florida residents, I could speak more directly to that, Dave. You said it was in a state out west, correct? Do you mind telling me which state?
In the Midwest, Illinois.
Okay. So it was Illinois. So it's going to be the time frame as far as the administrative function is going to be governed by Illinois statutes. And as far as whatever Illinois law says, which I am not an Illinois attorney, so I would, of course, defer to whatever Illinois attorney tells you as far as the time frame. Now, the Illinois attorney representing the trustee of that trust, are you the trustee of the trust, by the way, Dave?
I'm not.
Okay, so
my brother is.
Okay, so
there's no controversy. I mean, everything's settled.
So I would just have brother, since everything's amicable, have brother ask his attorney and say, what's the time frame on this? And if you're not terribly happy with the answer, you can always reach out to your own attorney that represents you as a beneficiary and get a second opinion on that time frame. That might be the wise thing to do. The actual preparation of something called a trustee's distributive deed, which is what you're alluding to, that's the mechanism, that's the vehicle. When people are talking about when do I get the physical paper that tells me I own this property,
right? That
takes maybe an hour's worth of work to actually pull the public record, draft the deed, prepare it, get it to the client, sign it, seal it, then you got to get it to recording. So, and it's not a terribly expensive recording process either. Oftentimes it's around $20. What county is the property located in?
Sarasota.
So, yeah, again, it's not a terribly expensive process to do something like that, but there's a lot of prerequisite, I'm sure, under Illinois statute. Again, which I am not licensed to answer, but an Illinois attorney will be able to tell you. So your question, just to help you put a point on the question to the Illinois attorney, is what is the time frame for my expectancy on receiving a distributive deed for this property? And that's really, to put a point on it, that's the question you want to ask. And they will very likely give you some sort of answer that's a time frame, because there's going to be, potential tax issues they have to settle, and, there's a backlog at the IRS right now. So at the end of the day, there may be a range. Be flexible, in other words. But you said there was a trust, that bodes well. In Florida, that would mean it's skipping probate. It's going to be much faster than going through a probate. But at the end of the day, the answer's still the same. I would check with a good Illinois attorney as far as the time frame. Trustees distributive deed, super simple work, not very complicated at all.
Okay, but I would need an attorney in Florida to do this process.
Yeah, I think the distributive deed should be done by a licensed Florida attorney. So oftentimes, Dave, I'll have clients come in, and they own properties in multiple states. And they're Florida residents, so I create their revocable living trust here in the state of Florida, and I'll deed their Florida property or their homestead property, any other Florida properties to the trust. But if they have a home in North Carolina or a home in Georgia or Illinois, as in your case, I would always recommend them to an attorney in that state. I think it's wisest to have an attorney licensed in that state move the dirt in that state into the trust, because each state has very particular rules about how to move their dirt.
Yeah, that's the counsel that I got from our Illinois attorney. He did say to get an attorney in Florida.
Yeah, your Illinois attorney gave you great counsel in that case.
Okay, good. But I was told, 6 months to a year, and I'm like, wow, that sounds like an awfully long time, but I just don't have a clue,
Yeah, and again, I would defer to the Illinois attorney on that, because it's governed by Illinois law, and there could be statutory delays, things that the statutes say you have to do. But again, if you're not happy with one Illinois attorney's answer, just check with another for a good, and it's not saying it's adversarial, just get a second opinion. And if they give you the same answer, then it's just a matter of the function of the statutes in that state. It's not really a commentary on any particular attorney or any particular beneficiary or trustee.
Got it. Okay, well, do you have any offices in the Sarasota area at all?
The nearest to Sarasota I probably have would either be Seminole or Sun City Center. One of those two would probably be the nearest location. Okay. So do you want the Pinellas County number?
I would love it, yeah.
It's 727-335-7094.
Okay. Well, thank you very much. I really appreciate your advice, and this program is very valuable. Thank you so much.
Well, Dave, we appreciate you calling in. Enjoy beautiful Sarasota.
You bet.
All righty. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. 877-943-9673. That's your toll-free number. Give us a call now. We'll answer your legal question absolutely free of charge. And again, another great day from you, the listeners. We've really run the range of questions all over the place as far as estate planning. And we'll be happy to continue answering your legal questions. 877-943-9673. You can give us a call now or email me during the week, patrick@attorneypatricksmith.com. Before I forget, let me give out the office locations one more time, the phone numbers. We have a office in beautiful Claremont, Florida, that you can reach that number, or the Fruitland Park, which that office services the villages. You can reach that office by calling 352-204-0305. Pinellas County for our office in Seminole, 727-335-7094. Hillsborough County for our office in Sun City Center, 813-755-8400. Again, for the Sun City Center office, 813-755-8400. For our Orange County office in Apopka, 407-606-7158, or the office in Haines City in Polk County, 863-445-9239. So feel free to give us a call. If you need all those office locations, feel free to email me, and you can get your own. And I'm showing the folks on Instagram and Facebook Live your own estate planning placard. We're giving these away absolutely free of charge. Tons of helpful information on here about me and about the practice, about our office locations, contact information. Again, these are absolutely free of charge. And again, toll-free number to reach any of our offices throughout the state, 877-754-6764. So you can call toll-free, 877-754-6764, and simply request your free estate planning placard. We will be happy to mail you one of these free of charge, so you have all our contact information. Again, that toll-free number, 877-754-6764. All righty, let's go back to Tampa and let's talk to William. William, welcome to the Attorney Patrick Smith Show.
Hey, Patrick, thank you so much. Appreciate your support for the community this way. I have a question, too, about an LLC.
William, go right ahead.
May an LLC be placed in a trust, and should every rental property have its own separate LLC?
So the first answer is yes. LLCs can be owned by a trust. It's typically a private stock share transfer. So when you get that corporate records book from whomever prepared your LLC and you say, what the heck is all this? You sort of thumb through it, and then way in the back, past your, articles of incorporation, your operating agreement, your bylaws, you'll see these stock shares, William. All right. Do you have your book handy? If you don't, next time you have it, dig it out. At the very back of the book, you're going to see some stock shares. Flip the stock share over, and on the back, you will see what we call the endorsement paragraph, where you can actually endorse your shares over to your trust. If all this sounds like Greek, William, we're happy to meet with you in the office free of charge and just show you how to do this. It's super simple stuff. So that's your first question. Should the LLC be owned by the trust? I typically recommend yes. Number two, should I have an LLC for each rental property? I think it's a matter of personal druthers, but here's the thing. It goes back to that medallion case. If you own Blackacre and Whiteacre in the same LLC and a liability comes up on Blackacre, can they go after Whiteacre? Yes, because it's in the same LLC. So if you had the Whiteacre LLC and the Blackacre LLC, now you have a steel curtain between the two. So I think it's a matter of your personal druthers. And the other thing you're going to run into is if your rentals are encumbered by a mortgage, you may run into some difficulties with transferring a mortgage or encumbered property into an LLC. A lot of times the lenders will balk at that. So the LLCs, the rentals transferred to the LLCs are typically free and clear as well.
Great. Okay. Thanks so much. We wondered about that. Appreciate your help.
No problem, William. We appreciate you calling in. Thanks for the question. This is Attorney Patrick Smith, and you're listening to the Attorney Patrick Smith Show. We're with you every Saturday morning from 8 to 9 to answer your legal questions. You can give us a call now, 877-943-9673, 877-943-9673, or you can email us, patrick@attorneypatricksmith.com. And again, that 800 number, if it's easier for you to just have that, to reach us to request your estate planning placard. I'm showing everyone front and back on Instagram and Facebook Live. 877-754-6764. Again, the toll-free number, 877-754-6764, to request your complimentary estate planning placard with all our office location, tons of helpful information, our price sheets, all absolutely free of charge. And you can also email me directly to request that, patrick@attorneypatricksmith.com. 877-943-9673. Still a few minutes here left in the show. Feel free to give us a call, 877-943-9673, and we'll get you and your question right on the air. And again, as I mentioned earlier in the show, if your group out there needs a speaker, we're happy to come out absolutely free of charge. Lots of speaking engagements lining up now. So you are welcome to get those set up through the office. Again, you can always email us, patrick@attorneypatricksmith.com. Call the toll-free number, 877-754-6764, and we will be more than happy to schedule a time to come out and speak to your group. If you're out there and you've just never done a will, maybe this is the time. This is the wake-up call for you to come in for your complimentary estate planning consultation. And, a lot of people think, well, I don't need to do that. I'm in my 20s. I'm in my 30s. I'm too busy. I don't have the time, or I can't afford to do a will. I would say you can't afford not to do the will. especially when our fee is $75. We try to make it economical because everyone needs a will. Everyone needs to have a plan put into place. And what you don't want to risk is a situation where some sort of terrible catastrophe happens, where the heirs are set by law and it results in a terrible outcome, like a situation where you have a child who's estranged from a parent, and then the child passes away suddenly, and the estate now is being divvied up between both parents, the parent that raised the child and the parent that abandoned the child, because the state code did that. A simple will can avoid a terrible outcome like that. All right, our last email question of the day from Peter the intern says, am I done once I sign my trust, or is there more for me to do? This is probably the biggest issue we see with clients. Trust funding. No, that's a lot like LLCs in that regard. Just signing the trust is not the finish line. It's the starting line. And then you want to go about, and we give our clients detailed instructions on properly funding the trust. It is a critical step, and we're always in clients' corners to answer their questions about funding the trust, making sure everything's properly titled. So you definitely want to follow those instructions and make sure you move your checking, savings, money market, bank accounts properly into your trust so that they operate optimally and avoid the probate process. Make it super simple for your family. Everyone, we really appreciate you listening to our second episode. This is Attorney Patrick Smith. This is the Attorney Patrick Smith Show. Again, to reach us at the office during the week, 877-754-6764. That toll-free number to reach me at the law office during the week to set up your complimentary estate planning consultation, 877-754-6764, or email me directly, patrick@attorneypatricksmith.com. Everyone stay safe, God bless, and go Gators.